Well, ladies and gentlemen, welcome to this Brickcourt Chambers seminar, I think, on telecommunications, some changes in the pipeline, which might have a slightly old industry sort of feel about it as a title, but I think it will serve to cover the matters we're going to cover. When I bashed a glass a couple of minutes ago, I didn't actually mean to bring everyone to attention, but they seem now to have locked the door, so I think perhaps we should make a start. I'm James Flynn of Brickcourt. My job, I think, only is to keep the show on the road and make sure that we finish in good time for drinks. There will be drinks, people. What I should say about that is that the tradition here is you leave the hall so that they can get the chairs out of the way and the drinks into the room. They pride themselves on doing that very quickly, and we can time them if necessary. So that's what will happen at the end. Before that, we've got quite a lot of material to get through, and I will introduce each of our three pairs of panellists as we go along. But before that, it's our pleasure to welcome and our privilege to host Professor Martin Cave, who I think will be known to most people in this audience, and I couldn't begin to summarise his CV. I think latest position is one at LSE. Martin, you'll put me right if I'm not correct on that. But an academic who has also rolled his sleeves up working for Oftel, Ofcom, the Competition Commission of blessed memory, and most recently the CMA. But he says he's now a free man and he can say more or less what he likes, and we're giving him 15 minutes in which to do that. So, Martin.
Okay, well, it's a great pleasure to be here, and I've spent the last 5 weeks sort of sounding off about all sorts of things since I finally left the CMA. But since these are very serious technical subjects, telecommunications, I shall display my normally moderation and common sense. Last week I was in Australia, so I really was able to let rip and all sorts of things, including particularly the energy sector. Well, I'm going to do my impersonation, and note that word, impersonation, of a Brexit-denying Ramona today. Because what I want to do as a start of this interesting seminar is set out some views and thoughts about the way in which the telecoms regulation world is going. And for us, as we stand at the moment, it's obviously determined largely by what happens in Brussels. And obviously the key thing that's happening in Brussels at the moment is the finalisation of the European Electronic Communications Code, which is the sacred book of telecommunications regulation, which of course is the gospel for all the national regulatory authorities and so forth in the currently 28 member states. So I want to say something about that, in particular to draw your attention to a rather interesting development which this new code has had to take into account, which I believe is of fundamental importance and is obviously a matter of huge topical relevance in telecommunications policy in the United Kingdom. So let's begin. What's the current European regulatory regime? Well, it's essentially the one which was founded in 2003 by the 5 directives and associated documents, the European Regulatory Framework. And I must confess, I'm always astonished at how well it's actually worked out. Those who study regulatory packages in other sectors will know that some of them are really pretty weird, and they also have to be repeated every 4 or 5 years because circumstances have changed. But one of the beauties of the 2003 package of directives is that they've required very little change, because they have introduced into the regime a kind of continuous but flexible deregulatory impulse. And that has actually been demonstrated in the 15 years or so in which they've been in operation. So I think they've been a great success. And I think it's also fair to say that the draft of the code and all that one reads in the papers about the various trialogues that are going on and the finalisation of them, that's basically going to continue with one very important amendment, which I'll come to in a moment, is going to continue with essentially that kind of basis. Now, I've chosen to adopt this rather elliptical approach because I know that my colleagues are going to be very expert in various matters, such as what will happen to the code vis-à-vis the United Kingdom when it emerges, as it probably will in about July or August, fully fledged. What will be the consequences when we're getting into the transition period and after the transition period? But I'm trying to avoid doing that and just sort of offer some kind of assessment of where I think it's going. Now, what's the interesting new bit, which I think is very important? And I think it's this, and it really is pretty fundamental, and it's basically concerns fixed communications rather than mobile communications. It's the miraculous appearance in some member states of very substantial levels of head-to-head competition within the fixed network system. Traditionally, when the code started, it was 2003. There were a number of copper-based local access networks in existence in almost all the member states, more or less ubiquitous, and a few cable companies, which were then treated for about 10 or 15 years with what I describe as benign neglect. But there was very little chance of anybody actually duplicating, introducing competition into fixed networks apart from that cable component. And the reason for that was obvious, that everybody knew that fiber networks were coming along, but they weren't ready yet in Europe, but we weren't brave enough actually to invest in them. And no sane person would dream of replicating an existing copper network in circumstances where its shelf life was likely to be very few years. So for the first 10 or so years of the regulatory framework, we were just stuck mostly with access-based competition, unbundled local loops, things of that kind. But then in about 2010, once people started turning their minds in Europe, maybe 15 years after them in Japan and Korea, then the question arose of what the new regime would be like. And there was a rather interesting bifurcation in Europe that occurred about that stage, and it occurred to a considerable extent because the Commission was dithering about what to do, and so it produced various drafts of a recommendation pointing in different directions, and so member states were able to go down different routes. And some member states adopted what I must say at the time seemed to be a very reckless policy, which was to say, in this new world of fibre, we want to create equal conditions for the incumbent and for new entrants to make investments, particularly in conveying fibre to the home, which is, of course, the very highest level of fibre that you can get, so-called full fibre. And we'll do that by basically opening up the infrastructure that's available in the country, and then, so to speak, challenging both the incumbent and anybody else who wants to throw their hat into the ring to make the investments. And clearly, there's an element, in principle, of achieving a kind of race to do this. Because all the best places, all the most lucrative franchises, so to speak, would be those which would go first. And if you could get your fibre into place first, then you stood a reasonable chance of gaining a quite substantial commercial advantage. And so this was an extremely bold approach, one which the Commission in the following years after 2010 excoriated to some degree, but the countries concerned persisted with it, particularly the countries in the Iberian Peninsula. And so they ended up, 10 years after that recommendation, with quite extraordinary levels of, to some degree, duplicated fibre to the home networks. Now, I say to some degree duplicated because this process, to some degree, initially at least, took place on a regional basis or a local basis, with one firm concentrating in one area and one firm concentrating in another. But you find that in some of those countries, it's actually been quite a substantial degree of overbuild. So it might be the case, if you were lucky enough to live in certain parts of Spain, that you might have access to two competing telco fibre to the home operators and also a very fibre-rich cable company. What's happening, therefore, in these jurisdictions is essentially what had been a monopoly has turned into an oligopoly. It's turned into something much more like the mobile sector than the fixed sector of old, where there's only one commercial network. And so the question is, how should regulation be reconfigured to take account of the new possibilities for this? Because as I've said, there's been a fairly profound deregulatory impulse in the European regime, and it looks as if it might go even further. It might begin to affect the local access network, and things might be done, tunes might be played on that hadn't been the case in the past. Now, I mentioned there was a kind of bifurcation between member states because some took that route, which was rather bold, possibly even reckless. Others took a much safer route, which was basically to maintain in a world of fibre to the node, that's to say not full fibre, but requiring access to the incumbent's copper loop. By taking that route, they essentially were sort of doubling down on the market power of the incumbent operator, because the incumbent operator was now playing a greater role than it had before in the copper era of unbundled local loops in the delivery of services. And that regime was extremely successful. In this country, for example, we achieved extraordinarily high levels of penetration of what we call super fast broadband. And there was a very quick and immediate payoff to that. But the difficulty with it is, in essence, that once you've achieved that, once you've conferred very substantial market power upon the historic monopolist, the local access provider, Deutsche Telekom or BT, in the form of Openreach, then it's quite a difficult thing to get out of. And as you'll be aware, Ofcom's policy and the government's policy, which is actually reviewing through a DCMS inquiry into broadband policy, is now very, very strongly in favour of, in some sense, moving on from the fibre to the node up to fibre to the home, and doing so by means of introducing competition. But it's having to do so in circumstances where, over the previous 10 years or so, that there had been, so to speak, an extension of market power by the historic monopolist, rather than the challenge to that organisation's market power that had taken place in the other sectors. Now, what happens? How does the regulatory regime react to that? Well, you can see an attempt to deal with this in the emerging findings of the European Electronic Communications Code. There's a much greater focus upon developing commercial wholesale markets. There are stipulations in that code which say, for example, that if you have 3 networks, then it's very unlikely there's going to be a company with significant market, and they're all have a wholesale offering. It's very unlikely there's going to be a company with significant market power which requires regulation. And so that aspect can join the not to be regulated component of the telecommunications sector, which, as we know, has expanded very considerably since 2003. But there is a problem, which is that the way in which that kind of oligopoly is dealt with from a regulatory process is by the application of the standard joint and collective dominance or joint collective substantial significant market power approach, which has proved extremely difficult to prove that there is such a thing, and regulators have tended to fight shy on. And it's therefore, in my opinion, very interesting that just a couple of weeks ago, the Dutch regulator has made a notification to the Commission in relation to local access that 2 companies, a cable company and a telco, are exercising joint dominance within that. The focal point of their collusion is that they do not offer access services, and the punishment mechanism for it is that there's going to be some kind of retaliation in the retail market. So it's going to be very interesting to see how this is going to turn out. Now, the Commission has also tried to make it easier, in some sense, for national regulatory agencies to adopt this joint collective dominance approach, but by rewriting the guidelines on market definition and market power, and that's going through. So let me get back to my point, since my time is normally up. What I'm suggesting is that there is already observable in some countries, and hopefully emerging in the UK, if those competitive impulses can be replicated over here. Not an easy task in the circumstances for the reasons that I've given. There is a chance that we are in fact quite likely to see an entirely different framework and structure of the local access industry. It's not going to be a competitive free-for-all, because we're talking here about there being at a max maybe 3 networks, probably only 2, and obviously in some areas which are sparsely populated, probably only 1. So all sorts of special arrangements will have to be made for those. Now, the question I want to bring my remarks to an end with is, from a UK point of view, does this kind of approach, that's to say, the regulatory framework renovated for the new world of oligopoly, as seems likely to be the case in the European Electronic Communications Code, does that provide a good solution for the UK? And I think I'd like to make a couple of points about this. Firstly, that the regime that we have in Europe obviously subjects our regulator to a degree of what you might describe as petty tutelage on the part of the Commission, the process of making notifications and receiving rather condescending comments on them by European Commission officials. I mean, I think it's fair to say that those might be to some degree wounding, but they aren't sort of catastrophic, because the Commission, as you know, is generally tends to be kind to larger member states than to smaller member states. Another question is, it's the case that the Commission, and probably the Code, will just limit the regulatory purchase on the oligopoly to the standard terms of joint and collective dominance or joint and collective SMP. Now, I know that there are people, including at some cases the chief executive of the regulatory body, and indeed the College of European Regulators, BEREC, who have said that we need something else, that it's too dangerous just to rely upon this method, which some people think is ineffectual, of proving joint and collective dominance and then proceeding on that basis. We need something else. Now, obviously, if we weren't bound by European rules, we could actually put in something else. But to be honest, I haven't seen a plausible account of what that something else would be, it would depart from the traditional SMP model, which wouldn't, in my opinion, introduce quite considerable risks of regulatory uncertainty, which might actually chill the whole business off. So that's what I would like to contribute to this. It's in a sense neutral as to Brexit, but not neutral as to the kind of regulation that we want to emerge from this. But I suppose my bottom line is that if we were forced, for various reasons, to follow the dictates of the European Electronic Communications Code, I don't think in any way that would be a disaster. Thank you.
Thank you very much indeed, Martin. Most stimulating and also bang on time, which is just what we need. Your remarks about the Commission being nicer to larger member states rang a bell with me when I once accompanied an Estonian delegation before their accession to a technical meeting at the Commission, at the end of which I said to them they really must want to join very much indeed if they were prepared to enjoy that level of sustained patronising over the course of an afternoon. But obviously they did, as they have joined. Well, the Bword has been mentioned, and Martin has done a good impression of a moderate Ramona, I should say. But we're getting straight into Brexit with our first panel. the members of which are to mine and to Martin's right. Stephen Hurley has the magnificent title of Head of Brexit Planning at BT, nothing but ambitious there. And he, like Matthew Braovac of Sky, has an extensive background in legal and regulatory issues, and we look forward to hearing their respective insights. Stephen.
I propose to cover five remarks in what I'm going to say, which will be a lot possibly more mundane than Professor Cave's more thoughtful introduction. But essentially what I wanted to talk about were touching on the regulatory framework and some of the comments Professor Cave started with, but also to talk about state aid, data flows, access to skills, and R&D collaboration, all of which I think are relevant, highly relevant in the telecoms sector. On regulation, I'm going to focus on the communications sector, but obviously the debate around whether in the future the UK stays closely aligned to EU regulations or seeks to diverge is a key debate at the moment. And as we've seen, the Prime Minister in her recent speech last Friday confirmed that the UK is going to leave the digital single market, possibly a statement of the blindingly obvious given what has preceded it. But clearly, from our perspective, the current regulatory framework, as Professor Cave noted, has worked well for the most part. It is grounded in EU law. It has, we would say, some important roles for the EU Commission. It also importantly enshrines Ofcom's regulatory powers and its independence. And it's been quite successful, we think, in ensuring investment and competition and across a wide variety of markets in our sector. And as I said, the framework also sets out some roles for the European Commission, which we think are quite important. On the policy side, clearly the Commission institutionally has the power to set the legislative agenda for the European Union, and this has been seen in the digital single market agenda, which continues to flow and will possibly do so throughout the transition and beyond. It adopts the guidelines and soft law, including those significant market power guidelines, which are currently under review, which help obviously national regulators in carrying out their duties, but also provide, I think, businesses quite a good degree of predictability and legal certainty. And finally, I think I would possibly take slight difference to Professor Cave's view on whether the Commission's oversight function, as it's possibly described, is condescending or not. In certain areas, we think it is quite a useful function beyond just the sort of purely harmonisation look across scanning across the EU28 to see where there may be, differences in regulatory approach. I think it also is helpful in emphasising some of the regulatory best practice and investment incentives that are enshrined in parts of the communications regulatory framework. I think potentially removing these roles of the Commission and enabling potentially widespread divergence from EU law potentially puts at risk what has been a fairly delicate balance over the number of years, with checks and balances on the one hand and strong and independent regulatory powers on the other. So given the fundamental importance of the sector, I think, to the UK as we move through Brexit, I think it's important that these oversight and policy roles are brought back in some shape or form to the UK as part of the withdrawal bill. I think whatever regulatory model we end up adopting post-Brexit, which again, Professor Cave touched on whether we stay close or decide to diverge in some material ways, I think a critical element of that regime will be a stable and proportionate regulatory environment with appropriate checks and balances. Turning briefly to state aid, the impact on Brexit here, I think, is a complex issue, given the way the arrangements work and that there's no UK domestic analogue at the moment. I think as set out in a recent report of the Lords Committee, the Lords EU Committee, the UK really does have some quite substantial decisions to make in this field. And the Prime Minister recently confirmed that the UK's intention is to stay largely in step with EU competition and state aid policy. I think from our perspective, the state aid regime has been helpful in ensuring careful and transparent use of public funds. It also allows the pursuit of public policy goals, but ensuring that they are only deployed where there's no risk of crowding out private investment. And in our sector, it's been used to deploy superfast broadband to 4.5 million households that wouldn't necessarily have it otherwise. So we think the regime can be and should be brought into the UK again as we leave. And in doing so, there may actually be opportunities, as we see it, to improve the regime as it stands. Currently, under state aid conditions, which are put in place when aid is granted, for example, in retail broadband, the aid can be subject to the condition that the access to the infrastructure which is used to provide the retail broadband should be opened up to adjacent markets, such as business connectivity, where there may not have been an assessment of market failure in the first place. We think that may be too wide and worthy of looking at. And procedural terms, there may also be opportunities to streamline some of the approvals process. Obviously, it can be a very lengthy process as it stands before the Commission. And also to improve the rights of intervention for companies affected, both the companies granted the aid and those that may seek to oppose. Turning to the topic of data flows, for BT this is particularly important as we're one of the largest movers of data globally. This is data both internally for our HR employee data, but also for our multinational customers around the world, where we have some 48 data centers scattered throughout the globe. And today, personal data flows, as many of you I'm sure will know, are facilitated by common EU standards, which are due to be upgraded fairly soon as part of the GDPR process. Once outside the EU, however, under the GDPR, it'll be illegal for companies based in the EU27 to share data with the UK unless they fall within a certain number of limited defined exceptions. And one such exception is that the UK is deemed to have adequate forms of data protection. And the Prime Minister has actually recently confirmed the desire to reach not only an adequacy assessment, but some form of enhanced adequacy, which allows a continued role for the UK's Data Protection Authority, the ICO. But I think in any event, ensuring this status quo continues and data flows are allowed to continue seamlessly flowing in the EU won't be necessarily straightforward. I think first, a fundamental part of any adequacy assessment will be quite an intrusive look at the UK's extensive surveillance powers, something that isn't carried out while the UK remains within the EU, but once outside will be open to scrutiny by the EU. I think secondly, and more importantly, possibly from a business planning perspective, is the question of timing. The most recent adequacy assessment carried out in relation to New Zealand took 4 years. So even with a 2-year transition, you can see a potential where we actually end up coming outside the EU data regime without any backstop in place. So I think businesses do need more clarity on this point, or otherwise they're going to have to start planning increasingly for the UK, at least temporarily, to come out of the current arrangements. Very briefly on future immigration and skills, turning again to the theme of infrastructure investment. I think it's vital that BT and other companies investing in the UK can access the skills and talent that we need. And from our perspective, this covers a very wide spectrum, from cybersecurity and PhD specialists on the one hand, right down to skilled fibre engineers and construction workers to roll out infrastructure. And it's this right blend of skills that I think we need to be able to build the next generation of digital infrastructure that the country needs. We're potentially already facing shortages in this space because of all the infrastructure projects currently underway, as you can imagine, with HS2, Hinkley Point and others. So closing down the borders or restricting access fundamentally could put some of these projects at risk. Finally, on research and development, BT is one of the largest R&D investors in the UK, investing over £500 million last year alone. And we've also been heavily engaged over many years in the EU's programs, so Horizon 2020 and some of its predecessor programs. And these programs we find them very useful in terms of not only accessing funds, but also collaborating with EU companies and universities across the EU. But they also ensure that the standards and requirements that come out of this collaboration can fit the needs of the UK. And in terms of practical benefits, the GFAS standard, which we're using today to roll out ultrafast broadband across the UK, came from some of the predecessor programs to Horizon 2020. So we're hopeful that there can be a sensible arrangement to allow the UK companies and universities to continue to work closely with EU partners. And again, this is something that was touched on in the Prime Minister's speech and the guidelines that came out today from the Council. So just briefly in conclusion, obviously I think it's fair to say that Brexit necessarily means a lot of uncertainty for business in our and other sectors. And fair to say, leaving the EU, as Professor Cave touched on, in the medium term and with considered thought, does potentially present opportunities for a more fundamental rethink of our regulatory frameworks, our immigration regime, and other aspects which can be tailored more closely to the UK. I think from our perspective in the short term, it's a priority under the withdrawal bill, and more generally that we maintain what has worked well in the short term and minimise what is already a very uncertain time for business. Thank you.
Thanks very much indeed, Stephen. Given a sense of reality there, Matthew, are you going to address us from the podium? Thank you.
So I think it's worth reflecting upon the fact that we also agree that the regulatory framework that's been in place since 2003 has largely been a success. And you know, that's not saying, it might feel like it's not saying a lot, but actually to have BT, the incumbent, the access provider, come up and say, generally, we like this, we think that it's rules-based, I think it's generally been pretty sensible. For, I represent Sky, an access seeker, typically on the other side of that debate, and if Professor Cave will forgive me, you know, I think regulators generally, as a whole, if we take that as a single view, have the same view. So that's really quite a success. And so I completely agree that, you know, we should recognize that given the amount of time that has passed, given the technological change that has happened in that time, for three protagonists representing those sort of different frameworks to come and say, actually, we think this has been pretty good, is really something, and doesn't exist in a number of other markets. You know, has anybody seen energy recently? And I would say that that's for two reasons. Number one, because it's rule-based, but number two, because it does have inherent flexibility. So I think the existing framework has enabled different regulators, as Professor Cave set out, to take different views. You might call it regulatory experimentation. And that's not necessarily a bad thing, because it allows the ability for different countries to take different approaches, for there to be a feedback loop, for there to be evidence gained. And indeed, it's quite interesting to see that precisely as described, whilst the UK started with a very service-based view of competition, it is now moving towards seeking to encourage infrastructure-based competition. And some of those countries in Southern Europe, Spain, Portugal, etc., who started with policies of not regulating access, for instance, above 30 megabits per second, are actually moving in the opposite direction. And so fundamentally, coming from two different places, the circle is made whole. Now, with Brexit, there is no doubt that there is an increasing possibility of divergence. And indeed, I also listened to the Prime Minister's speech on Friday, and the key phrase that we took away from it was, the UK will not be part of the EU digital single market. The UK is a world leader in this area and wants to retain the domestic flexibility to act nimbly and with ambition in this area. So nimble and ambitious. Now that's quite a statement. And it's particularly a statement when you think about how different that is from something that actually we've all here from within the industry and within regulators, etc., have said, actually, it's been working pretty well. Now, I would suggest that whilst Brexit is clearly one of the reasons why divergence is likely to become greater in the future, there are two other reasons that are driving it. One is the increasing politicization of decision-making and policy-making in this area. And I don't use that in a way of opprobrium, says the technocratic lawyer. Actually, we've got to recognize that political decisions have always been taken in our industry. And in fact, the liberalization of telecoms the privatisation of British Telecom, the creation of Mercury, the bringing in of competition, which was something that was led by the United Kingdom and where other countries in the EU have followed, was an intensely political decision. In fact, one might argue that it's not the kind of decision that can be taken at technocratic level. So political decisions don't necessarily mean bad decisions, because again, I think liberalisation, and what was done in 1981, 82, 83 has generally been seen to be a good thing. Number two, where we are in the investment cycle. Long-lived assets of the kind that we're talking about here mean that decisions that we take now will have very long-lasting consequences. And in particular here in the UK, as Professor Cave set out, there's relatively little fibre to the home, fibre to the premise rollout. It's clearly the question of the day. And what we do and what policy decisions are taken now will impact the way that competition emerges and the way that the market operates for a very long time to come. So with those thoughts in mind, we think there are three particular things that should be retained and are very important to be retained so as to ensure that we get good decisions, even if they're big decisions. They are Ofcom independence, which I think is absolutely fundamental, because we recognise that in order to take good decisions, government and others need an independent and a well-resourced and a technically capable regulator in order to carry out its functions. Secondly, we'd like to see appropriate checks and balances. So we'll talk later about changes to the standard in relation to appeals against Ofcom decisions. But there are also other things that were discussed previously, such as the current Article 7 process, which goes on between national regulators and the European Commission. We would like to see, if that's no longer going to be the case post-Brexit, we'd like to see a domestic equivalent put in place, whether that function is carried out by the CMA or some other body. And third, we'd like to see harmonisation where there are clear advantages of doing so. So, just to give a couple of examples of the sorts of regulatory experimentation that has already taken place under the existing framework, and to demonstrate that it's not the straitjacket that some Brexiteers might claim. I was going to talk about, for instance, the Spain and Portugal versus the UK approach, but we've kind of covered that. Some other examples, regulators had a relatively free hand in relation to some of their enforcement priorities. So whilst there has been a convergence of something called termination rates, which is the wholesale prices that telecoms companies pay each other for completing calls. And fundamentally, those started very wide apart, and it was the debate du jour when I first came into the telecoms industry many years ago. I looked recently, and the difference between the lowest rate for fixed termination today is the UK at about 1/20th of a euro cent, and the highest in the EU is Poland at about half a euro cent, a little bit less than that. Now, that's still, you could say, nearly 10 times, but it's many orders of magnitude smaller than the divergence that there previously was. And that's largely been driven by the fact that those issues have been fought out. We have established where we stand in terms of the law via various appeals, and then the soft law has taken over via various BEREC guidelines and other pieces of soft law which have generally brought those things together. But at the same time, there has been a particular problem with third-party countries that have got very high termination rates, particularly to basically try to expropriate cash, as the telecom companies would see it, into those third countries. So Pakistan, typically a number of the Caribbean countries, etc. And so telecoms companies say, well, hang on, I've got to charge a cost-based rate and you're telling me that it's down here, but equally, if I want to connect for international calls into those countries, I'm paying rates which are sometimes, many tens or even hundreds of times greater. That's fundamentally just an outflow of cash from one to the other. And so it's been interesting to see that without necessarily codifying it particularly, different regulators just kind of took a view on whether or not they were really going to enforce the cost orientation or the price controls, particularly on international calls. Equally, spectrum policy is an area where, generally speaking, people agree that harmonization is a good thing. There are major benefits of economies of scale if you harmonize when spectrum bands become available. There's clearly equipment costs that come down if there's a sort of harmonized plan. But when rolling out spectrum, different regulators have taken different approaches. The German regulator took a sort of celebrated approach to 4G that required operators to roll out in rural areas before they were permitted to roll out in cities. In the UK, we didn't do that. And maybe if we had, we'd have slightly less Daily Mail headlines about mobile coverage today than we do. There was also a difference between those coverage obligations and market value. There's a trade-off between how much revenue governments want to raise versus how much coverage they want to get. So I would conclude by saying there are definitely going to be the opportunity for quote-unquote big political decisions. The Green Paper, which has been previously referred to in relation to future telecoms infrastructure, the Future Telecoms Infrastructure Review, asks some very big questions about how we're going to upgrade and fundamentally improve the telecoms infrastructure in this country. I don't want to turn this, and I promise not to turn this into in any way a party political broadcast, but take, for instance, the question of structural separation, which has been a running debate for some time. I think it's fair to say the possibility of structural separation is greater now than ever, because it's one of those things which is not in the common regulatory framework. Although Ofcom had a legal view that the exceptional circumstances provision would permit it to be done so, but it's not explicitly there. You have to read it purposively in order to find it. In a post-Brexit world, well, that's not quite the stroke of a pen, but it's certainly something that's easier to be brought in than it is today. But with those greater possibilities of big decisions, I think it's important that those are good decisions, and that therefore means that they need to be informed with an independent Ofcom, a series of checks and balances, and harmonization, where you can see real benefit of doing so. Thank you very much.
Many thanks indeed, Matthew. Very interesting insights, and obviously a challenging note to end on, which we might come back to. Our second panel is on the subject of net neutrality, and is going to be led by the last of our guests on the panel this evening, Alexandre Verheyden from Jones Day in Brussels, who has a very solid competition and regulatory practice, and he will be followed by Robert O'Donoghue, who I will wake up if necessary, as he's just finished a 6-week trial of these chambers, whose practice is outlined on the sheet, and you don't need me to big him up any more than he already is. So, Alex, thank you.
Good evening, everyone, and thank you for having me. I usually say that I prefer to speak than to have slides, but I've lost some of my voice, so I wish I had some slides to back me up. Net neutrality, and we've discussed the interplay between the technocratic side of our job, and competition law tend to be on that front, and the political aspects of it. And net neutrality is clearly a political topic, and it's basically a question of where you strike the balance in terms of access to networks between those who pay for the pipes or the transmission capacity, consumers who want to have free access, or at least access at the minimal costs, to OTT services who are helping and satisfying customers' needs, but are also deriving significant benefits from the overall ecosystem. And we've seen that on the 14th of December of last year in the United States, they've decided to completely change the regime. I would profess I've printed the material, but I haven't digested them. It's 500 pages long, and they were only recently made available. I don't think that they will curtail internet access completely, but at least it was presented at the time as a major turning point where there would be a move back on the open internet in the United States. The reason why I'm mentioning this is because something which we take as a given is at the end of the day the result of a political compromise at a given moment in time. Now, where do we stand today in Europe? It's the Regulation 2120, which harmonized a lot of the existing practices which emerged in the EU since the year 2010. And I mean, I'm biased because we try to challenge the initial regulation on roaming. As much as I had doubts as to the need for a harmonization of law for roaming, I think for net neutrality, there is no question that you had different practices and it made some sense to try to harmonize. So where do we stand today in terms of net neutrality in the EU? And what I'd like to explain today is to give you a brief snapshot of what exists, and most of you have heard about this, but it's the conflict between what we see today in the regulation and what could have been done and is not being done in the new electronic communications code. And I'll come back to that because I do think that there is a balance which has been struck in the regulation, and it's like it's a sacred balance, and you will see that hardly anything is going to change under the new framework. But where do you stand today in terms of net neutrality? Basically, you have three types of rules. One, it's one that protects end customers, so end users have the right to access and distribute information and content through the internet, so it's one obligation that applies and protects end users. The second provision that regulates net neutrality is the principle, and it's an agreement, it's the prohibition to restrict the right to access the internet via an agreement between the ISP and the end user. And that provision is not interesting for what it says, but it's interesting for what it doesn't say. Because in fact, what this allows is that it allows any types of agreements between ISPs and end users, provided that they do not restrict that access to the internet. And which means that each ISP can define the programs of their choice and have different type of packages depending on what of the consumer or customer is prepared to pay. That's the second pillar to the net neutrality rules applicable in Europe. The third one is a prohibition to, or rather an obligation to treat all traffic equally, which is imposed on internet access service providers. Now, it doesn't mean that each package needs to be sent at the same speed. It's all understood that networks are not totally stable, but you cannot have the speed and quality of the transmission vary depending on where you surf on the internet, or depending on where the site or the type of site that is being surfed on is located. And so there is this general principle that no discrimination can be implemented at the level of the ISP in terms of internet access. Now, it's quite striking because I went through the BEREC guidelines, and while there is a real an effort to try to explain what this is all about, I find the guidelines quite confusing. And it's one thing that you guys may gain from leaving the EU, is that because BEREC's documents are typically, I mean, you know how it works at the BEREC, you've got one country that takes the lead, and then they do the report, and the quality sometimes varies depending on who does what. But when you read the BEREC's guidelines, they basically tell you that we don't prohibit zero rating. So zero rating in theory is possible, but then when you read it, you're struggling to try to understand where it would be possible to start applying different standards or different rules based on zero rating. And sorry, for those of you who are not aware of this, zero rating is the ability for an ISP to provide for free the transmission capacity when you surf on certain websites, either because it's an internal website of the ISP, and that's precisely what people want to avoid, is that the ISP leverages local loop connection to gain a competitive advantage on when it acts as an IoT, or because it has entered into an agreement with a third-party IoT provider. And where do we stand on zero rating? As I said, when you read BEREC's guidelines, it's hard to say where we stand, because you don't get much guidance out of it. But you've had several cases at the national level in relation to zero rating, and these have taken place in Austria, Hungary, Norway, Slovenia, Sweden, and Belgium. I hear that there is one coming up in the UK. I must say I'm not on top of that particular case. But what comes out of this in terms of zero rating is that there is now some tolerance for zero rating services, provided that the service does not result in the ability for the zero rating service to carry on once the user has used its limited package. Because in that case, all the internet services are being degraded because the package has been utilized, except for those very limited applications where the customer continues to be able to serve. In that particular case, these applications have been consistently, and I'm thinking more about this, the Austrian and the Belgian case here, those type of applications have been outlawed, or at least have been regarded as a type of illegal zero rating. If, on the other hand, the zero rating practice is taking place as simply a add-on benefit in the context of the overall package, limited package purchased by the consumer or customer, that practice is accepted in a number of member states. So you see some possibility of zero rating services emerging at the national level. But regardless of how technical this debate becomes, if you take a snapshot of where we stand today on net neutrality, by and large, there is no restrictions on net neutrality. The internet is completely open, and that's the view that is being taken for the moment in the EU. And this raises issues as to how the debate is being handled at the level of the Electronic Communications Code, which is being discussed today. When you read the legislative history, and it's not complete because the code is still being discussed today, it's obvious that there is a certain recognition that OTTs are no longer the small garage operation that they were 15 years ago. They become huge players, and they are in a position to to dictate their, and it's not the case for everyone. That's why the situation is extremely complex, but you have to admit that Facebook is not a nothing competitor. So there are some very large OTT out there, and there is a definite decision to try to catch OTT to some extent in the Electronic Communications Code. So there is that recognition which is being accepted in a sense. How do they do that? They are changing the definition of electronic communication services. Up until today, electronic communication services are based on the notion of conveyance of signals. And in the new definition, you have three components to electronic communication services. you still have a catch-all, and I mean, I should be finishing, but it's the easiest one, so I'm starting with that one. You still have a catch-all category of all other services which consist in the conveyance of signals. So these are still the good old telecom services. You have a second category, which corresponds to the internet access services, which is the exact same definition of internet access services as the one you find in the regulation 2120. So you see that there is a certain caution from the European legislator here, because they are trying to avoid upsetting this political deal that was reached under the regulation on net neutrality. And so when it comes down to defining electronic communication services, they simply reuse the definition of internet access in the code. And then you've got a third category, and that's where OTT will come into play, called interpersonal communication services. And these are the services which no longer require, technically, the conveyance of signals. And it's under that category that OTT services are potentially caught by the Electronic Communications Code. Now, the draft doesn't go very far, and I can tell you that, to my knowledge, the points of definition are not what was negotiated between the Parliament, the Council, and the European Commission. So I don't think the actual scope of the code will change much. But we can take it as a given that now, regardless of the technology used, voice calls, all email services, messaging services, and group chats will be caught by the Electronic Communications Codes. But you're going to have all the other services which are still going to be left outside the code. And very often you have some questions to whether or not, it's good to access networks and pipes. What about interoperability and accessing some of the OTT services so that you can develop software that becomes and can interact with theirs? That issue is, it's a political decision which has not been taken so far, and that's why, for the time being, if you look at how the balance is struck, we're still in the old game of regulating telcos with very little regulation for OTTs. For those OTTs who will be caught by the definition, the one area where number independent, because they make a distinction between interpersonal communication service which are based on numbers and those which are not based on numbers. So number independent interpersonal communication services will be subject to some regulation to the extent it's necessary for emergency services or for end-to-end connectivity. But that's a very minor area in terms of access and in terms of type of obligation that can be imposed on OTT services. And therefore, this tells us one thing, is that the access regime under the new code very much maintains the status quo in terms of access obligations for providers of electronic communications services, and in terms of leaving out of any kind of interoperability obligations most of OTT services. I would like to conclude by stressing that we all share the great appreciation of the quality of the old framework and the new framework. There is a slight frustration that I have, is that we were all promised in 2002 that regulation was temporary and competition law was going to take over, and at the end of the day, the level of regulation was going to disappear gradually. And I agree with the point that was made that the regime is so flexible that basically in this ideal world where competition would suffice, we can remove all obligations. But if you look at how the current access obligations are being discussed today in the code, in fact, regulators are trying to make their task easier than before. In past, they had a good old regime of SMP status, so what we call asymmetric obligations, so asymmetric because obligations imposed on only one operator, which is the dominant, the S&P operator. But there is a new little door that was opened in 2002, which is becoming extremely large. Today is the notion of symmetric regulation, because you start to have some concrete examples, and France is a good example of that. When you impose symmetric access, and so obligation on all operators in terms of in-building coverage, you stimulate rollout of fiber up to a concentration point, which is not far away from those buildings where the in-building wiring has been rolled out by all operators. And on the basis of this experience, the code is retrying, and I think one of the points of discussion that are taking place this week have to do with trying to increase the scope of these symmetric obligations. And of course, once you impose symmetric obligations, the type of regulation becomes quite easy for NRAs, because you just impose the same obligation on everyone. There is no market, there is no Article 7 procedure. It's a much simpler process. There is some consultation that is taking place, but the options of challenge before court are much lower. The other reason why they are trying to make their life easier is this whole debate on collective dominance. I may not be totally biased here, but I recognize the need to be able to capture situation of oligopoly. But the danger that I see here is that if you apply these air-true criteria, it's all a question of how you apply the air-true criteria. Those criteria are quite clear. The problem is that, when the Commission applies it on an ex-ante basis in the context of a merger case, they have the files, they have the emails of the parties, and they can identify in the file specific elements that justifies and that form the basis for their assessment. The fear I have with the new framework is that it gives a lot of flexibility to NRAs to identify a potential issue, but then they will not, since they have a lot of discretion as to how they interpret the facts, and courts defer to the NRA's discretionary power in this regard, it is likely to become an open door as well to increased regulatory power. So the judgment is still out as to whether or not I think the new framework will manage to strike the right balance between competition and regulation, and if we are not in the process of opening many doors that will facilitate the job of regulators, but at the end of the day may have backfiring effects. Thank you.
Thank you very much indeed, Alex. And to reciprocate the courtesy, Robert is going to do his presentation in French.
Right. I'm going to come at net neutrality from a slightly different perspective, which is, to some extent, a constitutional question. So everybody, I think, in the room knows that there is a net neutrality regulation. And as Stephen and Matt have indicated, our Prime Minister indicated last Friday that among the cherries we will not be picking is the digital single market. And I think some Ramoner has called this managed ambitious divergence, or MAD for short. Now, as Alex said, the net neutrality globally has been extremely controversial. On the one hand, you have essentially almost a fundamental right to, on a consumer basis, to unthrottled and unrestricted internet access. And on the other hand, you have the obvious problem that if service providers can't price discriminate or discriminate in other ways, if they haven't got market power, in most cases, that will limit efficiency. So you've got this collision of ideas. And for what it's worth, in this country, prior to the regulation, the appetite from Ofcom for anything to do with net neutrality was pretty thin. Now, from a constitutional perspective, so we have this political choice which can be made, but from a constitutional perspective, based on the withdrawal bill, which is in flux, how we get from A to B to C is fiendishly complicated and has a lot of bear traps along the way. So what I want to do for the next 5 minutes is sketch out some of these problems and see where they lead us. So the effect of the bill in its present form on a regulation such as this is that directly effective EU law will no longer have effect in the UK. directly effective EU law will not have primacy over UK law, and direct EU legislation becomes part of domestic law by virtue of Clause 3, and this includes regulations. Now, the Governor said that the legislation which is converted into domestic law by Clause 3 of the bill will form part of a unique and new category of domestic law. Retained direct EU legislation will operate in a different way to both primary and secondary legislation not made by UK legislators, and will have a unique status within the domestic hierarchy. Now, in many ways, this causes more problems than it solves, because it is unclear whether this means mere domestic law or something unique, albeit not actually recognizable. And this matters from a number of perspectives. First of all, the domestic courts have the power under the Human Rights Act to interpret legislation compatibility with the Convention, and by contrast, treating retained direct EU law as primary legislation will render it immune from judicial review on non-Human Rights Act grounds. Now, looking further ahead in terms of legislative and judicial changes, so as many of you know, in Article 9 of the existing regulation, there is a 3-year review clause which comes up for activation quite soon. And what if the regulation is amended post-exit? Now, what Clause 5.3 of the bill says is that the supremacy principle may apply to pre-exit domestic legislation, even if such legislation is modified on or after exit day, provided that the application of the supremacy principle is consistent with the intention of the modification. Now, as you will apprehend, that tells us more or less nothing about what exactly is going to happen if and when this is amended. Now, on the judicial side, there is, of course, the Court of Justice, and there is pre-Brexit and post-Brexit case law. Now, what we get from Clause 6 of the bill is that the English courts are to decide in accordance with the retained case law, i.e. the pre-Brexit case law. And there are 3 caveats or provisos to that. This only applies in respect of retained EU law insofar as that law is unmodified on or after exit day. It applies only insofar as retained case law is relevant to the question about retained EU law. And English courts can depart from the retained case law on the same basis as they could do in relation to their own case law. So there is a consistency to that extent. Now, in terms of post-Brexit case law, you won't be surprised to hear, the bill provides that domestic courts are not bound by the CJU's post-exit case law. They are not required to have regard to post-exit case law, but may do so if they consider it appropriate. Now, these words are clear as far as they go, but as to their practical impact, your guess is as good as mine. Now, on preliminary rulings, the government's position is that the EU withdrawal will necessitate a cut-off point for references. The timing of that cut-off point will depend on if and when there is a transitional deal and if and when that starts and ends. There will be an important need to address pending reference cases, and for many litigation parties, there will be issues of procedural fairness and access to justice if for some reason they fall at the wrong side of the cut-off point. So this, I think, will be controversial in a number of respects. Now, looking further ahead, the well-known Henry VIII powers, there is a Clause 7.1 which provides for ministerial regulation. And again, it is put in strikingly broad terms. So a minister may by regulations make such provisions as the minister considers appropriate to prevent, remedy or mitigate A, any failure of retained EU law to operate effectively, or B, any other deficiency in retained EU law. And again, the language is striking. The appropriate is subjective and wide, and the failure to operate effectively and deficiencies, again, your guess is as good as mine. Now, what Clause 7.1 doesn't do is distinguish clearly between an amendment which is necessary for a legislative measure to make sense in the context of Brexit and discretionary amendments that are intended to implement what are in reality policy changes. And there are limitations in Clause 7.7, and by and large for net neutrality they tell us very little. The only thing perhaps which could be of some interest is C, which is you cannot have new criminal offences created, and perhaps B, that you can't have retrospectivity. But beyond that, we're not told very much. Now, very, very quickly, I'm conscious of the time. One parallel development, of course, is that in addition to net neutrality, or perhaps in place of net neutrality, we would have to consider a suite of other domestic legal provisions that would apply in parallel. Obviously, you're aware of competition law, and by and large, it has pretty limited teeth when it comes to net neutrality. For B2C claims, obviously, on the C side, the consumers will not be undertakings typically, and therefore will not be able to sue as parties to anti-competitive agreements. Now, one final point I wanted to pick up on, which is a very interesting case from a couple of years ago involving Lebara and Leica. And what happened in that case, so this was pre-regulation, and the claimants in that case used a series of economic tort arguments to construct a version of net neutrality that was attenuated compared to the regulation, but considered arguable by the judge. Now, I've given you a number of references there for the ways and means in which these net neutrality provisions were constructed from economic torts. And it may be that some of this stuff comes back with a vengeance if and perhaps when net neutrality is modified post-Brexit. So I think in summary, this is going to be fiendishly complicated in quite a state of flux, and very good news if you're a constitutional lawyer. Thank you.
Much indeed, Robert. Those slides will be made available in some way or other, probably via our website, so you'll be able to study those at your leisure. Our final panel is on the new standard of review for Ofcom decisions, the importance of which Matthew has already highlighted for us, and will be addressed by Sarah Ford and Sarah Love, who's again have very interesting practices. I couldn't begin to guess the secret of success of my colleagues' practices, except looking down the line, I noticed that all of them are left-handed. Interesting. Sarah Ford.
Not to be outdone, I also have some slides. And as advertised, I'm going to say a few words about the standard of review that the Competition Appeal Tribunal will be applying to determine appeals against decisions of Ofcom. A quick reminder of the previous position. Section 1952 of the Communications Act 2003 provided the tribunal should decide the appeal on the merits, and that essentially boiled down to the tribunal asking itself, has the decision maker got something materially wrong in this case? The new provision now, Section 194A2 of the Communications Act 2003, now provides that the tribunal has to decide the appeal by reference to the grounds of appeal set out in the notice of appeal by applying the same principles as would be applied by a court on an application for judicial review. Now, that provision came into force on the 31st of July 2017, and it applies to new decisions of Ofcom which are taken after the 31st of July 2017. So what does it actually mean? There's not actually a great deal of mystery about how the Competition Appeal Tribunal will actually apply the judicial review standard to issues of competition and regulatory appeals. And the reason for that is that the standard already applies to certain appeals to the CAT. For example, it applied to appeals from decisions of the OFT, now the CMA, on mergers. And it also applied to appeals from the decisions of the Competition Commission, also now the CMA, a different wing. So we do have some insight already into the way in which the Competition Appeal Tribunal might approach things. And I've cited one of the cases which is very frequently then recited by the CAT in its judgments. And it's all pretty familiar stuff. The starting point is the decision maker has to take reasonable steps to inform itself as to the matters necessary to make the decision. Having done that and having then taken its decision, in considering whether that decision actually has a reasonable basis, the test is one of rationality. And although the tribunal itself is a specialist tribunal, it will exercise restraint in trying to second guess the judgment of the expert regulator. And when the decision maker gives its reasons for the judgment that it's reached, those reasons are then governed by familiar principles set out in the Porter case. So it's all familiar public law stuff. The more interesting question, I think, is in the light of the new standard of review, if you're an appellant, how can you give your appeal some teeth? And what I've done is I've identified 4 ways in which you might try and encourage the tribunal to exercise a more rigorous standard of review. The first one is a time-limited opportunity, so you need to take advantage of it while it lasts. Article 4.1 of the Framework Directive requires the provision of an effective appeal mechanism, and in particular, it tells us that the merits of the case must be duly taken into account. And the case I've cited there, T-Mobile, was a debate about the correct route of an appeal from Ofcom. One possibility was that it had to go to the CAT, the other possibility was that it had to go to the admin court, and T-Mobile's argument was, well, you can't send us to the admin court because it will be inconsistent with our right to an effective appeal under Article 4.1. And the answer of the Court of Appeal was, well, no, judicial review is flexible and it can be adapted to accommodate the requirements of Article 4.1. And that raises the odd possibility that we might have a slightly different standard of review prior to Brexit, and then after Brexit. Prior to Brexit, there may be an ability to flex the judicial review requirements in order to accommodate the requirements of Article 4.1, and post-Brexit, potentially, you might find that that then doesn't apply. Second possibility, convention rights. We've already got authority in the BAA case that where you have convention rights in issue and where the public authority has an obligation not to act disproportionately in the context of those rights, then the requirement that that authority must investigate appropriately and the requirement as to the evidential underpinning of its decision may be more rigorous than it otherwise might be. And that is potentially helpful in the context of regulatory appeals because there quite frequently will be some sort of convention right drawn into the appeals, and the most obvious example is Article 1 of Protocol 1, the right to property. So if you have appeals involving, for example, access rights or the imposition of remedies, it's quite potentially the case that you can say, well, this draws in Article 1, Protocol 1 issues, and so you need to apply a more rigorous standard of review. One note of caution on that, though, is that the extent to which the tribunal is prepared to apply that more rigorous standard depends on whether or not there's some sort of economic or social element involved in the issue. The more the issue before the tribunal and the issue before the decision maker has an element of economic and social judgment, the less the tribunal will be prepared to say, okay, well, we're going to look behind that decision, and the greater the margin of discretion that will be accorded to the decision maker. Third possibility, the doctrine of use of power for an improper purpose. Now, this is a doctrine that was developed in the context of the powers of local authorities who had come up with various cunning schemes to expand their means of financing their activities. And although they had what appeared to be ostensibly fairly wide statutory powers, the courts have said, actually, you can look behind the statutory power and inquire what was Parliament's intention when it conferred this power, and is what you're doing consistent with parliamentary intention. And that is also a useful principle in the context of regulatory appeals, because it means that you can get into a scrutiny of what Parliament intended behind the power in question and whether or not the outcome is actually consistent with the intention. And that really opens the door to a much more substantive inquiry and substantive debate before the tribunal than simply inquiring whether the decision had any adequate basis or not. And the final possibility, the doctrine of jurisdictional or precedent fact. Now, the point here is that the decision maker's jurisdiction, which will be defined in the statute, may be dependent on the existence of a factual state of affairs. So the jurisdiction is essentially a condition precedent to the exercise of the jurisdiction is a particular factual state of affairs. And the courts have said, in those circumstances, you can't allow the decision maker to expand its jurisdiction on its own by making a decision and getting it wrong about the facts which underlie its jurisdiction. So if you have a jurisdiction which is dependent on a factual state of affairs, you don't simply say, well, the decision maker has to have a reasonable basis for having reached a view on those facts. The court will positively inquire about the correctness or otherwise of the decision that the decision maker has come to. And the most recent and most relevant example of that, and the justification for the picture of a ferry, is the C France case, which was a case about whether or not there was a relevant merger situation for the purposes of the Enterprise Act. And the key debate was whether or not the question of a relevant merger situation is something to which the tribunal ought to give a lot of deference to the decision of the CMA. Was it something within the CMA's specialist expertise, such that the tribunal should stand back and give it a lot of leeway, or was it something where the court could exercise a bit more scrutiny? And there was quite a lot of debate below, and then in the Supreme Court, Lord Sumption dealt with it in a single paragraph quite crisply. And he said, first of all, the existence of a relevant merger situation was a precondition of the authority's jurisdiction. So that's a reference to this doctrine of jurisdictional fact. And we know that that means that the court is prepared to scrutinise the facts that underlie the decision. He then said, the test to be applied is a question of law. It depends on the construction of the Enterprise Act. And again, a question of law is something that the tribunal is entitled to decide for itself. It doesn't actually have to have deference to Ofcom in relation to questions of construction. And Lord Sumption said, well, there may be limited circumstances where the CMA's expertise may come into play. And the example he gave was, well, if you're construing a statute, different constructions might have economic implications, and you might then defer to Ofcom in terms of the implications of different constructions. And he also said, when you apply the test to the facts, again, there might be some specialist economic judgment involved that Ofcom is particularly well placed to do. But leaving aside those really quite limited areas, the Supreme Court said the CMA's expertise and the specialised nature of its functions do not clothe it with any wider power to determine its statutory jurisdiction than is enjoyed by any other administrative decision makers, and its conclusions on the point are entitled to no greater deference on review or appeal. So it's really saying, insofar as this is a question of jurisdictional fact, that's a matter for the tribunal. There's no great deference to the decision maker. So again, another doctrine that is really going to be helpful in getting behind the sort of the deference to the specialist regulator and asking the court to apply a more rigorous approach. And it's a concept which might well have application in telecoms appeals. For example, if you think about the imposition of SMP conditions, the finding that somebody has significant market power is a factual question, which is a precondition of the power then to impose SMP conditions. And so you could say the Competition Appeal Tribunal must properly scrutinise any conclusion of significant market power, because it's a jurisdictional fact, a precondition to Ofcom's power then to impose SMP conditions. So it is potentially quite a powerful tool. So by way of conclusion, although there has been a change in the standard of review, a little bit of ingenuity, and there is scope for having an appeal that still has teeth. Thank you very much.
Now, you've just heard from Sarah about what difference the new standard of review is likely to make and how appellants could make sure that their appeals still have teeth. And what I would like to do is to start by taking things back a stage and actually asking, what is the purpose of the new standard of review? What was this change intended to achieve? And then, in the second part, I would like to, assuming that that purpose is a valid one, and assuming that the new standard of review alone is not going to be the silver bullet that one might hope for, have some very brief thoughts and suggestions on how appellants and also tribunals might actually go about achieving that aim. Now, partly in the spirit of the technical progress and the relentless technological improvement that we have heard about this evening, and also mainly, quite frankly, because I'm the last thing between you and your wine, so I need to mix this up a bit. I'm going to be drawing in the course of this on some examples from the field of space exploration and space technology. So let us start with the aim. Why introduce Section 87 into the Digital Economy Act? Now, when I looked at this, I found that there had been, in the space of 2.5 years, no fewer than 3 consultations between late 2010 and mid-2013 on the topic of the standard of review for telecoms appeals. In September 2010, there was a BIS consultation. In August 2011, there was a DCMS consultation. And then most prominently, in summer 2013, there was a further BIS consultation on streamlining regulatory and competition appeals. And all of those covered the issue of communication appeals to the CAT. Now, I know that proposals to modify various aspects of the tribunal regime do come up from time to time, but that's really quite striking. That's more than once a year this issue is being revisited. So that suggests that, at least in the eye of the government, there is a problem. Now, we have heard a great deal of things in the first panel about things that are supposed to be positive about the current regulatory regime. So the question is, what actually is the problem? What is the issue? What is the mischief that this new standard of review is going to fix? Is it the case that lots of Ofcom decisions get appealed, that none of them are? Are the procedures so complex that communications providers just sit helpless, unable to know where to start? And having looked through the consultations, I think probably a very succinct statement of the problem, or at least the perceived problem, can be found in the explanation that was given by the Minister when what was then Clause 74 was introduced. So we start with the notion that there has been gold plating. Now, I leave it aside whether there actually was gold plating on the previous standard in Article 4, because that in and of itself is my 10 minutes gone, and that also isn't really the practical issue. And then we come to the heart of it, which is basically the length of the appeals. So the message I got very clearly on reading through these consultations, especially the 2013 BIS one, is that the central issue in the eyes of those who made these changes, is that appeals to the CAT from Ofcom decisions were considered to be taking too long, which in turn made them too expensive. So having established the problem that appeals are taking too long, let us try to get a bit more concrete about what too long, very lengthy and costly looks like. And I think it is now time, you've been sitting very patiently, it is now time for a bit of audience participation. BIS in 2013 looked at CAT appeals on the merits across all areas that were heard between 2008 and 2012. And they looked at the total length from when they got registered at the tribunal to when judgment was handed down. Now, show of hands, who thinks that the average was between 2 and 2.5 years, so 24 to 30 months for those appeals to get completed? No one. This is a period in which you have PPCs, local loop unbundling, you have pay TV, you have the construction cases, you have tobacco. No bidders at 2 to 2.5 years. Who thinks 18 to 24 months would have been the average? Oh, show of hands, show of hands. 12 to 18 months? Most popular so far, 6 to 12 months? No. None of you have been cheating, because the answer was 11 months. Now, frankly, I don't think that's that bad. When I had this tech ready, I had my picture of Buzz Lightyear to infinity and beyond to illustrate the current problem. But I really don't think that 11 months is a particularly problematic figure. In fact, as someone who was involved in the pay TV litigation, I actually wondered whether the first figure there was a typo and should have been a rather higher digit. And I should also add that the Competition Appeal Tribunal has subjected these BIS figures to quite detailed scrutiny in its own consultation response in 2013. So that may, if anything, be a slight overestimate of what the position was. But let us take it at face value that 11 months from start to finish for a telecoms appeal on the merits is a problem. 11 months is too long for an appeal, and what we are looking for are ways in which we can speed this process up, thereby trimming some costs. But we do not want to compromise on the quality, and we want our appeals still to have teeth. Now, faster, better, cheaper was the approach that was pioneered by NASA under Daniel Goldin, their longest-serving administrator, and it governed the way in which they went about formulating missions to Mars. So with that inspirational thought in mind, here are my top 3 suggestions for how appellants and tribunals could work together to transform the speed of telecoms from the current Victoria House norm, which is apparently an average of 11 months, to NASA-esque speeds. I think the NNA is nimble and ambitious in the current environment. Now, number 1, grounds of appeal. The first thing, and I think it is absolutely, absolutely central, is that to achieve much shorter telecoms appeals would require a real change of approach towards grounds of appeal. It would require, frankly, a ruthless selectivity and focus on key issues, what I think the tribunal in the APCC's appeal described as the points of material significance. Now, the tribunal could obviously influence this somewhat indirectly and incentivize a narrow approach by how it handles costs, but I think this one is actually mainly down to appellants, and I think it actually isn't really about the standard of review, it is about the entire approach. Because even if you start with saying it's not just enough to have the points that you think you would have done differently, what do you think is wrong? What do you think went wrong in the assumptions, the factual inputs, the calculations, the process, and what was wrong in the conclusions? The aim really should then be at least to cut your list in half, and for every single point of appeal that you are running, to think, is this central? If I win on this, am I going to get a remittal on a sub-point of a sub-point of a sub-issue on how a certain part of the market thing was done? Or am I actually going to make a difference and knock the whole thing down? Now, for inspiration here, there is a photograph of the 4th liftoff by Falcon 1, which is the first privately developed rocket by SpaceX that was launched into orbit. And after 3 fails, they eventually achieved it by a relentless focus on the design essentials. They were aiming to minimize cost per launch and increase reliability, so they went with the concept of the minimum viable product, which was the smallest useful orbital rocket. And I think if we actually wanted to make real inroads into 11 months, the concept basically has to be the minimum viable appeal to get the outcome you want. Expert evidence. Now, I think there is scope for a really interesting debate about how well the tribunal is assisted and actually how well the parties are served by the current position in relation to expert evidence. There is a divide between the factual witnesses and the independent experts, who are those who meet the Icarian REFA standard with which we are all familiar. And the difficulty that you encounter in telecoms appeals, and I'm sure it's also common in a lot of other specifically regulated sectors, is that a lot of the issues are actually going to fall somewhere between those 2 stools. There can be intensely technical matters, what the actual technology is, how it works, what are the incentives, what influence the choice of technology, but they are not necessarily matters on which you want an expert economist opining. And they are often matters where the people who are best placed to opine will be from the communications provider itself, but they obviously don't meet the independence requirements. I'm not saying there is no role for expert economists. I think, though, it is a very tightly defined one, and the difficulty in the present situation is that quite often one either has expert evidence that is at a very highly theoretical level, so it is therefore several removes away from the actual issues that are being decided, or involves experts opining on matters when they don't really have the detailed technical expertise. This is an area where I think the tribunal could get more involved, but in the meantime, I would encourage you to think very carefully about whether a matter on which you propose to adduce expert evidence, and it usually is expert economist evidence, is a matter on which expert evidence is going to be helpful. Because you could spend a lot of time and money on expert reports and also generate responding reports when there is an easier way. Now, you may be wondering about the picture. I think we're all familiar with the idea that the Americans spent millions of dollars to develop the Biro pen because they wanted a pen that worked despite in a zero-gravity environment, and the Russians used a pencil. It's actually not true. As I found out this morning, it's an urban myth. They both started with pencils but ditched them because the graphite flakes and they're a huge fire hazard. But again, the question of whether we could be producing pencils instead of space pens is, I think, one that appellants and the tribunal could be taking on board. Finally, the teaching. This goes to the previous point I was making about technical complexity. I think that these are a hugely helpful and potentially enormously time-saving resource. I think those of you in the audience who work at the sharp end of the communications provider, the technology aspects, you cannot possibly underestimate the base level of knowledge of most of the lawyers and tribunal members involved. You'll see there a picture of Dr. Robert Goddard, who was the physicist who was credited with creating and building the world's very first liquid-fueled rocket. And he is apparently lecturing to some university physics students. Does he have equations? No. Picture, Earth, moon, pictures, house, telephone line, fibre. It really helps and it saves a huge amount of time. And I think this is something the tribunal could take the initiative on. We're all familiar at the first CMC with the agenda for the case management conference, the venue, etc. The concept of the teach-in should almost be the norm, and it should be scheduled much more regularly, even in a very tight appeals process. Now, finally, and acutely conscious again, as I said, of the time, I end on an upbeat note of what might be possible. I said that faster, better, and cheaper was a NASA motto that influenced its Mars missions, but the ultimate example of success of faster, better, cheaper is actually that of the Indian Space Research Organization, which launched its Mars Orbiter mission in November 2013, and it's been orbiting Mars since September 2014. There are 2 points that I think are about MOM, which are particularly interesting to the present context. It was built at a cost of $75 million, possibly slightly higher than the average cat appeal on a telecoms matter, but it's about 1/10 of what NASA was spending. But the other thing, more interesting, is that it was 15 months in the manufacturing from end to end. It was approved in August 2012, and it was ready to go by the end of October 2030. That is slightly less time than it took for the partial private circuits appeal to be completed. So if you can get to Mars in 15 months from scratch, you can get a cat appeal done against even a complex Ofcom decision, I think, for much less. Thank you.
Thank you very much, Sarah. And I think we should also note that Sarah is instrumental in setting up this evening, which I think we'll all agree has been rich and stimulating. It will no doubt provoke a lot of questions, but the good or the bad news is we have run out of time for the questions, and those will have to be put to panellists or amongst ourselves over a glass of wine, which will follow very shortly. As I said at the beginning, the way it's done here is that you leave the hall and in amazing time they clear it and turn it into a sort of drinks party suitable arena, and that is about to happen while we'll reflect on whether we can achieve faster and better and cheaper, or just some of those, and how the tribunal is going to manage, as we've seen with recent fast-track cases, on improving on an 11-month start to finish of anything complex is possibly, again, something we can discuss over a drink. But meanwhile, can you join me in thanking all the panellists for a most stimulating evening?